You post something on your personal Facebook account. Not at work. Not about work, just your life. Your opinions. Your identity. 15 years later, that post could end your career, not because of what it said, because of who got angry about it. Right now, in a federal courthouse in Texas, a judge is being asked to answer a question that affects every single public employee in America. Does the government get to punish you for legal speech you made as a private citizen? Just because enough strangers online demanded it? The answer to that question is going to surprise you. And it's not what either side of this fight wants you to think it is. This is really a story about one principle, one school district, or one controversy. It's a stress test for the First Amendment itself, because buried inside this case is a legal doctrine most Americans have never heard of. Something courts call the Heckler's veto. And once you understand it, you'll start seeing it everywhere, in workplaces, in schools, in your own social media feed. Here's the deal, I'm not here to tell you who's right in the underlying political fight. That's not what this video is about. What I want to show you is the actual legal machinery, the tests, the precedents, the doctrine that determines when the government can and cannot punish you for what you say off the clock. Because once you know the rules, you'll never look at a controversy the same way again. Let's start with what actually happened. In May 2026, a Fort Worth school district promoted a longtime educator. 13 years in the district, chemistry teacher. Assistant principal. The whole track record. They announced it publicly. Posted her photo. Case closed, congratulations, new chapter. This detail matters more than it sounds like it should. The district had already vetted her. Background checked, social media reviewed, approved. This wasn't a surprise hire. Then the internet found her old posts. Not recent ones. Some over 15 years old. A college coloring contest entry. A 2009 photo supporting DACA. A Black Lives Matter profile picture from 2020. A repost about a school board meeting on masking policy. A profile picture with a Palestinian flag overlay. And a shared article explaining what Sharia law actually means as a personal practice, not a political system. Within days, a coordinated online campaign, bloggers, social accounts, organized outrage, flooded the district with demands for her removal. Here's the pattern to notice, because it's the engine of this entire case. Nothing she posted was new. Nothing was illegal. Nothing was said in a classroom. The only thing that changed was that strangers on the internet decided to be angry about it. And here's where it gets constitutionally interesting. Because what the district did next is exactly the kind of decision the First Amendment was built to police. Within 4 days of the announcement, the district reversed course entirely. One administrator told her to lock down her Facebook, but reassured her the posts had already been cleared. Hours later, 2 regional chiefs showed up in person to deliver her involuntary reassignment. The district deleted its own announcement. Sent out an internal memo. Opened an investigation. She was locked out of onboarding, transition meetings, hiring fairs, everything she needed to actually start the job she'd just been given. A month later, the district held a formal investigation meeting and questioned her, point by point, about 6 specific posts. All published outside work hours. All on personal devices. All on personal accounts. None of them ever mentioned a student. None of them were said in a classroom. This is the exact fact pattern that triggers First Amendment public employee law. And there's a specific, 3-part legal test that decides whether speech like this is protected or whether the government can punish it. So what is that test? Let's break down exactly how courts decide this, because it's not a vibe check, it's a formula. There are 3 questions a court asks in order when a public employee says the government punished them for speech. Question 1. Were you speaking as an employee or as a private citizen? This comes from a Supreme Court case called Garcetti versus Ceballos. The rule: if you said something as part of your actual job duties, the First Amendment doesn't protect you. Your employer can control your job-related speech. But if you said it as a private citizen, off the clock, outside your job description, different story entirely. This is the first gate. If you fail it, the case is over before it starts. Nothing here was a job requirement. Nobody's job description includes post a coloring contest photo in college, or share a news article about religious practice. These posts were made over 15 years, on personal time, on personal devices. That's about as far from official job duties as speech can get. Question 2. Did the speech touch a matter of public concern? This comes from Connick versus Myers. The standard is broad. Does it relate to anything of political, social, or community importance? Courts don't require the speech to be important to everyone, just that it's the kind of thing that matters to public debate. Immigration policy, racial justice after police shootings. Public health mandates during COVID. A repost about what Sharia actually means, shared right as Texas was debating legislation about it. Under this standard, that's about as squarely public concern as speech gets. Question 3. Even if it's protected speech, did it actually disrupt the workplace enough to justify punishing it anyway? This is the Pickering balancing test. And this is where the real fight in this case lies. But here's the real question this raises. If the answer to questions 1 and 2 both point toward protected speech, can the government still win just by saying, but it caused a controversy? This is the doctrine that makes this case bigger than one school district. It's called the Heckler's veto. Here's the principle. The government is not allowed to punish your protected speech just because other people got loud, angry, or threatening about it. If that were allowed, the loudest mob, not the law, would decide what speech is permitted. Anyone could silence anyone else simply by manufacturing enough outrage. In this case, the district's justification was operational disruption, parent complaints, public controversy, pressure on the superintendent's office. But courts, including the Fifth Circuit, have repeatedly held that anticipated or speculative disruption caused by external backlash doesn't count. The employer has to show the speech itself, not other people's reaction to it, caused actual, material harm to how the workplace functions. Think about what that distinction actually protects. It's not protecting the original speech because it was popular. It's protecting the process, because the alternative is a world where the angriest group with the biggest social media following effectively gets veto power over who keeps their job. This is the test to watch for any time you see a public employee disciplined after a social media pile-on. Ask whether the employer is pointing to actual disruption that already happened, or just pointing at the outrage itself as the disruption. But the First Amendment claim is only half of this case. There's a second, completely different constitutional question sitting right next to it, and it might actually be the stronger argument. The second claim isn't about free speech at all. It's about equal treatment under the 14th Amendment. To win this kind of claim, you don't have to prove your speech was protected, you have to prove you were treated differently than other employees who did the exact same thing, and that the difference in treatment was driven by discrimination. According to the complaint, other district employees, outside this protected class, posted nearly identical things. BLM profile frames. DACA support. Mask policy posts. None of them were investigated. None were reassigned. None had their promotions deleted. There's also a legal principle from a case called Village of Arlington Heights. Courts can infer discriminatory intent from the sequence of events. Here, the district approved everything before the public photo went out wearing a hijab. The reversal happened only after an organized backlash specifically targeting her visible religious and ethnic identity. When you're evaluating a claim like this, the question isn't, was this person treated badly? It's, was this person treated worse than someone else, doing the same thing, who doesn't share their protected characteristic? That comparison is the entire engine of an equal protection claim. Now, the district has one more argument left in its pocket. A state law, it says, justified all of this. And whether that argument holds up depends entirely on what the law actually says, not what it's being used to do. The district pointed to a Texas law, Texas Education Code Section 28.0022, as its justification. This law was written to govern something specific. How controversial topics get discussed inside the classroom. It limits how teachers handle current events in instruction. It restricts certain curriculum content. That's its entire scope. But none of the posts in question were made in a classroom. None were part of curriculum. None involved a single student. They were private, personal, off-duty expression. The exact category this statute was never written to touch. This is a pattern worth recognizing anywhere you see it. A law written narrowly for one purpose, classroom instruction, gets stretched to justify something it was never designed to cover, private off-duty speech. When you see that stretch happening, that's usually the weakest point in the whole argument. And this isn't the first time a Texas district has had to draw this exact line. But the comparison actually works against the district's position here, not for it. Fort Worth ISD has handled cases like this before, and the difference is the whole ballgame. In two prior cases, the district disciplined educators who used social media to call for the deportation of their own students, directly, by name, targeting kids enrolled in their own schools. Courts upheld those firings because that speech created a direct, material conflict with the district's duty to keep students safe. Compare that to this case. General posts about national heritage, religious identity, and political topics, never naming a student, never targeting anyone in the building, never connected to instruction. This is the distinction that ends up mattering most in court. Targeted speech aimed at identifiable people the institution has a duty to protect is treated completely differently than general political or religious expression. Collapsing those two categories into the same kind of misconduct is where a district's legal position gets exposed. This case doesn't exist in a vacuum either, and understanding the bigger picture around it changes how you read everything that happened here. This case sits inside a wider pattern across the country, a Virginia school district facing a lawsuit after suspending students over a viral video trend, a New York district that erased a student's artwork after a Facebook campaign, settled for $125,000, a Maryland district facing litigation over teacher social media posts. A private school in Houston where a pre-approved cultural display triggered an internal investigation that ended in the resignation of the head of school. The mechanism repeats almost exactly. Pre-approved or personal expression of identity, followed by an external pressure campaign, followed by an institution reversing course, fast, often before any actual investigation is complete, and there's specific context fueling that pressure in Texas. The state's governor formally designated a major Muslim civil rights organization, along with another group, as a terrorist organization under state policy in late 2025, citing historical federal trial evidence. The state's attorney general then filed suit to bar the organization from operating in Texas. The organization has pushed back hard in federal court, calling the designation defamatory and politically motivated, and a First Amendment violation in itself. That same designation has already had downstream effects. It's been cited to exclude Islamic private schools from a state voucher program, prompting separate federal lawsuits from schools challenging that exclusion as discriminatory. You don't need to take a side in that separate political fight to see the point clearly. When state-level institutions create that much pressure, local school boards making fast, reactive decisions isn't happening in isolation. It's happening inside a much bigger political current, and that context helps explain why a district might move quickly without waiting for its own investigation to finish. So where does all of this actually leave the law? Strip away the politics, and you're left with a fairly clean legal structure. On the First Amendment claim, Speech made as a private citizen, on a matter of public concern, with no proof of actual operational disruption, just public controversy, has historically been protected speech. Courts have repeatedly rejected the idea that outside pressure alone justifies punishing it, on the equal protection claim. When other employees do the same thing and face no consequences. And the disciplinary action only starts after the employee's identity becomes the target of public attention. That timeline becomes its own evidence. This is exactly why the Heckler's veto doctrine exists in the first place, not to protect any one viewpoint, but to stop outrage itself from functioning as the law. The next time you see a public employee disciplined after an online firestorm, run it through these same 3 questions. Was the speech made as a private citizen? Did it touch a matter of public concern? And is there real evidence of actual disruption, or just the controversy itself? That framework will tell you more about a case's legal strength than any headline will. So now you understand how courts decide whether your off-duty speech is protected, and how a heckler's veto can't legally be used against you. But that raises the next question. What happens when the speech does cross into the classroom? When a teacher's political opinion stops being personal and starts becoming instruction? That's a completely different legal test, with a completely different outcome. If you want to understand exactly where that line is, and why some teachers have lost that fight in court, that's the next video.